Hello and welcome everyone to Season 3, Episode 3 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. My name is Alessa and I'm a member of the ARBinBRIEF team. ARBinBRIEF videos, in collaboration of Equal Representation in Arbitration Pledge and Lagos Chamber of Commerce International Arbitration Center, offer a quick resource to consult on issues that arise in international arbitration while showcasing talented arbitrators in an interview format. Today, we'll be discussing a topic on effective expert witness testimony in international arbitration. I'm honored to introduce our arbitrators for today, 𝗔𝗥𝗕𝗙𝗥𝗕𝗙 and Ara Cho. Krista is based in London, 𝗔𝗥𝗕𝗙𝗏𝗔𝗥𝗕𝗙. She specializes in engineering, construction, and energy disputes. She's regularly appointed as arbitrator in ICC and LCIA arbitration proceedings. As counsel, she has worked on projects concerning, amongst others, power stations, wind farms, electrical, and gas infrastructure. Ara is a partner of Peter and Kim. She's based in Seoul, and she's acted as counsel in numerous international arbitrations under ICC, LCIA, SIAC, and KCAB rules. Been involved in cases arising from a range of international projects, including design and construction of power plants and refinery plants. For those who are joining us live today, the 15-minute interview will be followed by a 15-minute Q&A. And the 15-minute Q&A will take place in another Zoom session, and the link and details will be in the chat. During the Q&A, anyone who wants to will be invited to turn their cameras on, and we encourage you to actively participate and ask our arbitrators questions. Without further ado, we'll start today's session. So just starting off this session, I just wanted to ask our panelists today, what is the general practice in your jurisdiction regarding the use of experts in international arbitration proceedings? For example, are they typically party appointed? In addition, are there any procedural rules or laws unique to your jurisdiction which apply to the appointment of experts in arbitration seated in your jurisdiction? So perhaps Krista, you could answer the question first.
So in the UK, experts are generally always party appointed. This tradition comes from the English court style, which isn't inquisitorial. So it's up to the parties to present and prove their cases. This includes how they present expert evidence. But the difficulty becomes obviously when you have experts appointed by the parties, how does the tribunal determine the differences? First of all experts have to undertake to be independent and impartial, understand that their duty is to the tribunal, even though they're party appointed. But what I think we have developed, which is unique, is this idea of without prejudice discussions. We encourage the experts at every stage to have without prejudice discussions, which means they're not disclosed to the tribunal. Only the outcome of their discussions are disclosed, whereby we try to encourage the experts to agree what the issues are, what methodologies they're going to use, agree the source data, and even agree the outcome of issues. So after their initial reports, they'll meet again to see whether they can narrow the issues. And so in the end, what the tribunal has to do is just discuss and decide the outstanding issues that the parties can't agree on. And generally, if the experts are acting professionally, that's very few issues.
Thanks, Krista. Ara, maybe you can share with us what happens in Seoul.
Thank you. Korea is a jurisdiction of like civil law jurisdictions, and as with some other civil law jurisdictions, Korean courts usually rely on court-appointed experts when it determines that it needs an expert opinion. So actually, when I was first starting the practice, and the Korean clients who are not really familiar with the arbitration, they were very some of them were surprised to see that the parties actually appoint their own expert. So that's And actually, in the Korean Arbitration Act and KCAB arbitration rules, they actually have the provisions related to party-appointed arbitrator, the expert, the tribunal-appointed experts, unlike some of the other rules. For instance, like Korean Arbitration Act refers to the possibility of the tribunal-appointed expert, and actually, and also provides the situation where the parties can challenge the independence of the experts, which has the same standards as the arbitrators. And KCAB arbitration rules, again, has the similar provisions within that. So that's something, I guess, different from what Krista has explained regarding the tradition stemming from the English court practices. But having said all of this, however, in practice, the parties, like even if he's seated in Seoul, the arbitration practitioners are more used to these party-appointed experts. So in case of the international arbitrations, we usually rely on party-appointed experts' evidence as well. But given the background that I just explained, I think the Korean, the arbitrators from Korea, I think are more prone to, more open to the idea of the tribunal appointed experts.
Okay, thank you. That's interesting from given the kind of the differences between Korea and what happens in London. So just leading on to my next question, this is for Ara. As counsel, how best would an expert assist in presenting your case? If you have any examples of how an expert may have made a significant difference to a case you handled?
Yes, sure. So I guess the most obvious example would be when the procedure is bifurcated and divided into liability and quantum, and when you are into quantum phase. You inevitably have to work really closely with your quantum experts. That's one of the cases where assistance from the experts is very critical. And another area I think is really critical to have a right expert is sometimes there are technical issues, of course, that needs to be opined by the experts. And like, for instance, in one of the cases I've been involved in, in order to figure out whether the certain work was additional work that entitles the contractor to receive the additional amounts, that kind of depended on what is the general practice in the region in light of the weather conditions and otherwise, because the contract itself had the provision to the effect that you have to design the facility in line with the general practices in the region. So actually, many of the issues we had to be turned on by what the experts say, the technical experts say regarding the general practices of which materials should be used or which criteria should be used in the design, so forth. So yeah, and lastly, the one area that I think sometimes like delay experts, they are the experts, but they have to go through the whole history of the projects inevitably. So in doing so, I find that sometimes how the delay experts present their opinion very important in presenting the case explaining the case and actually the facts to the tribunal, because they're eventually saying that what was happening and what was actually like driving the delay or the progress of the project.
Oh, okay. Thank you. Thanks, Ara. Now, from the other side of the table, Krista, as arbitrator, what are procedures you would propose to counsel for experts to present the evidence, and what are factors you would consider in choosing which procedure to use? And would this change in the event that there's a tribunal-appointed expert?
So generally, by the time we get to the tribunal, the aim is that it's only the difficult expert issues that are left. So generally, these are issues, there might be delay issues, technical defect issues, which will be typically difficult, that I won't have much understanding or prior knowledge of. So to resolve this, I like to have what I would describe as a sort of teach-in session. So I would invite both experts to give a presentation at the beginning. So this is before the expert evidence starts officially. They would give like a 15-minute, half an hour presentation. I think this works well because it enables the experts to explain to me, the tribunal, what the issues are, how they see it. And the UK tradition is quite aggressive in terms of cross-examination. And that's not always the best way to get the evidence across to the tribunal. And so it enables them to have a free opportunity to explain the issues. As Ara says, so a delay expert can set out those key factual chronologies and understanding. And then as well, I feel that they settle in more into the role when they're then under cross-examination and the evidence comes across far better. So after that initial presentation, there's the choice between traditional cross-examination by counsel and hot tubbing. Generally, my way of doing things is to allow cross-examination by counsel. Counsel have been working on the case for much longer than I have. They know the issues, they know the vulnerabilities. So in a way, as the tribunal, I trust them to highlight the difficulties with the evidence. But sometimes when the issues are not that difficult, often with quantum, having to choose between two figures, then it's good to have the two quantum experts in hot tub and I say, well, item one, what's your view? What's the other view? And it's easier way when you have just a schedule of several defects or several items of quantum. So that's how I would normally organize the expert evidence.
Thanks for your insight, Krista. Now, on our last question, both as counsel or arbitrator, have you seen any trends in the way in which experts now present complex or technical information? So, Krista, you can
So
get this.
I think for a long time we've had PowerPoint presentations. That's very typical. But what I have seen develop with COVID and with virtual hearings, often what stops experts presenting is because the tribunal and counsel don't have the relevant software. So even delay programs, we don't have that software. But now with screen sharing, experts can share their technical models in whatever program they can to the tribunal. So that's something I'm seeing develop.
I see. What about you, Ara? Have you seen any recent trends in cases you've done?
Yes, I was going to mention the similar point as Krista mentioned. With the video hearings become more usual after during COVID. The one of the benefit in video hearing is you can share the screen, and it makes difference in terms of when you are using these specific programs. And for instance, like even the Excel programs used by quantum experts, it's one thing to look at the printouts and go through them as a cross-examination or as direct examination, but to actually go through the models and explaining. So I think it kind of helps what exercise has been actually done for that issue, and I personally find it very useful in terms of understanding the analysis of the experts in certain areas. And another trend I would say is I think, as Krista also mentioned, sometimes I think the more and more tribunals tend to think that the cross-examination of the experts is not always the best way to get the accurate evidence and to actually understand the issues. So there are many like hybrid ways that are being tried. Like I don't see a lot of cases where the cross-examination itself altogether is waived, but usually it's you have the cross-examination, but still the experts are sitting together, and the tribunal can kind of actually ask the questions while the cross-examination is going on. And if the tribunal wants, they invite the other side experts to comment on that specific question. So you kind of mix the witness conferencing and the cross-examination. And also some tribunals, I think, wants to hear experts' views on a list of issues, or sometimes even at the document production stage, whether certain documents are relevant to material. So they kind of try to set up this procedure hearing quite apart from the main hearing, to kind of let the experts speak about these issues. I think that's one I guess trend that I've been noticing.
Thank you. Thanks very much, Krista and Ara, for this incredibly insightful discussion. So we've actually come to the end of the 15-minute discussion. So at the end of this episode, we would just like to thank our partner organizations again, the RA-Pledge and LACIAC, for the invaluable support. For those who are watching us over YouTube, our video ends here. Thank you for joining us. And to see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe our channel on YouTube. We'd love to hear your comments and feedback. For those joining us live, we now have a chance to pose a couple of questions to Krista and Ara in a more interactive way. To join the Q&A session, you need to join a new Zoom webinar using the link posted in the chat box. Reshma has just posted it. So just click on that link with the details there, and we'll see you there right now. So the 15-minute session will begin now. Thank you very much, everyone.